Hello, Lyric Armstrong, your real estate agent and advocate. I am here. Um, we're getting ready to go into the YSL Young Thug updated trial. We had ourselves a great time doing jury watch for the Kieran Reed trial. So you can check that out. That's what we did earlier today. The verdict came in while we were live. And so we had our thoughts on that. So check out that video. Right now, let's get into a YSL trial. As we stated before, we knew that, okay, thank you, Law and Crime. Make sure we thumbs up them. Law and Crime Trials channel. We knew that they were going to come back on the 1st, and let's see what they actually put on the record, because they're supposed to be doing in-camera review outside of the presence of the jury. And I think they're outside of the presence of the jury because Mr. Williams, Jeffrey Williams, is quite comfortable. This is not him, but he's quite comfortable in his attire.
I'm trying to.
Look at this. There we go. All right, so there
Mr.
he is. He looks like he's in a tracksuit.
All right, halt, Mr. Good morning here. Let's see, C18 record.
Right. Now, like I told you before, what's the roll call? This is the adult version of taking attendance.
All right, ladies and gentlemen, we are back. Let's see. We're back on the record in the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. Let me go ahead and take roll for the morning here. Let's see. Mr. Stilwell, Mr. Botts, and Mr. Shard. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, and Miss Haltwinger. Is Mr. Adams going to be with us today, sir? Okay, all right, okay.
So what happened the last time when we were going into contempt with Ben Steele? Mr. Adams said, we work in tandem. I can't do this trial, the material critical parts of this trial without my colleague. So take me to, Your Honor. And the judge says, no, you cannot exhort the court. Guess what? You get to be the representation. He has two attorneys, so you get to represent. Well, this is kind of the reason why both attorneys need to be wherever they need to be, because we don't know what part of the case that they're taking on, what part of the evidence is what they were researching and doing the discovery on and, you know, ready to rebut, or what part of the case they need to have information firsthand on. So Mr. Steele is like, I need to be available to all of the evidence firsthand, and I can't do it from a jailhouse. So they brought him back out. And now Adams is not there. So Adams is like, I don't need to be in every situation, but still does. We'll see what
okay, we have Mr. Kendrick and Mr. Weinstein. Mr. Ewing, Mr. Matthews, Jr. and Sr. All right, Mr. Nichols, Mr. Harvey, and Mr. Garner. Is Mr. Youssef over there in the corner? Okay, all right, okay, thank you. Mr. Ryan and Mr. Williams. All right, good morning. Miss Hilton, flying solo today?
Flying solo.
Okay, all right, okay. All right, good morning, madam. All right. Councils, we're trying to deal with some video issues that we're still having from Zoom, but that's part of the ancillary matter. The court is going to talk with you about the release of the transcript. I have an order that I'm still working my way through, so it will be probably less than an hour. I'll come back, just wanted to put us on the record and put you all at ease, and then we'll go ahead and we'll cover that, okay? All right, so we'll be in recess about an hour or thereabouts. All right? All right, we're in recess. See y'all about 10.
I don't think that Rusty would be here today if it wasn't for the.
All right. Sorry. Sorry, everyone. I'm eating, so I didn't want to eat on camera. So they're in recess. So let's get past the commercial of the cute dog. Okay, we'll pass that. And then let's get into where we're supposed to be, because they have come back from recess. Obviously, this was some time ago this morning. So let's, we don't have an OnlyFans. I wonder if anybody's gonna miss the Karen Reed, Massachusetts OnlyFans. They like to zoom in on the placard thing, but they don't do it. Sometimes it's blurry, as we can see right there. However, we are grateful that we do have the YSL trial to take a look at and some other things to catch up with, especially with Judge Simpson's court. So we do have other court. We're thankful that the courts are being more forthcoming in broadcasting live. All right, yeah, it's been a little more than an hour. Okay, almost 2 hours. It allows us to learn. So thank you all judges and courthouses that are streaming. We appreciate the transparency and making it a more public accessible forum for us to learn different concepts. And it was unfortunate for the end of the Reed trial, but ladies and gentlemen, we are past the OnlyFans and we are saluting the state of Georgia's Constitution. Here we go. We shall now get back into court. Okay, I don't have any sound. There's the sound. Hopefully you can hear it. Okay, I don't know who this is. Maybe he's another defendant, but law and crime, we like to see the whole courtroom. We don't want to zoom in and count boogers. So can we see the rest of the courtroom? Oh my gosh. I even hate that when it's like playoff season and you're watching the game and they're all zoomed into the player. Can we see what's going on in the whole space? Okay, you shouldn't just... hey, attorney, this is when you're talking to your client, you got to do this. You have to cover your mouth. So use an envelope or a folder to cover your mouth. You don't want anyone reading your lips because they're zooming in. Where's the judge? Can we get back on the record? Are we moving? I know. What are we doing? Okay, there.
Where's Mr. Weinstein?
Oh. Music?
Where's
Wait a minute. Wait a minute. Hold on, sir. I don't think it's allowed for you to listen to music.
Mr. Weinstein. Okay, all right, okay. All right, thank you, Deputy Ham. Anybody else joined us since we last recessed, other than Mr. Uhalski, who I haven't seen so long, he's grown a mustache? Anybody else? Okay, all right. All right, folks. As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that'll be marked as courts 2. So the transfer will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or I had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Kayla Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:30.
Sorry, you can't see or hear me, huh? Sorry. So he paused when it came down. He paused when it came down to attorney Bumpus's name, because he feels like she's the one who snitched on the ex parte hearing. But according to the records of the court, she said there was 14 people coming and going, and the judge just read off who was there. He said, aside from the court, Love, Hilton, Bumpus, and Copeland. So the court is representing 10 other people. Is that what you're saying, Your Honor? We're just doing rough math here. We're not exact math, just rough.
4 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch And Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking Mr.
What world are we in? What lunch? We saw, okay, hold on. Maybe you took lunch because you took lunch, but that's not what the court had in recording. The court recorded that we were taking a 5-minute break so that Copeland could change his clothing. What day are we talking about here? Why is he talking about a lunch? They ended up having a very long break because it becomes more apparent to Mr. Steele and Mr. Weinstein that something happened, that there was an ex parte hearing earlier that morning, and that's why it took roughly 2 hours, if not more, for the court to get on the record and be at the bench, because the judge was in the back in ex parte. And one of the things that became, highly noticeable to them is that not only is the judge not ready at the 9 o'clock hour for which he called the hearing, neither are the 88s. They're not visible either. So everyone else is in the back in ex parte meeting without their knowledge, without their waiver. We get on the record, he testifies. They're like, well, wait, why is he testifying? And he says, oh, well, and that was the other thing. Ben Steele goes, I don't understand your other. When we left off on Friday, you said we were going to have a hearing this morning to find out if Mr. Copeland witness was going to continue testifying because he pled the fifth. He is a sworn witness who pled the fifth on Friday. And the judge says on the record, well, the only thing I can tell you is that his attorney has represented, Ms. Bumpus has represented that he is going to testify. So he gets up, he testifies. And in the middle of his testimony, he goes, Your Honor, I need a break. And can I take my sweater off? I want to take my sweater off. And so the judge's like, okay, well, we'll take a 5-minute break. They ended up taking a longer break, but the record doesn't say we're going to go to lunch and allow him to take off his sweater, get more comfortable. We'll come back from lunch. What is this? It's like recreation of history. That's the thing. Oh, that's the thing. Remember, the appeals office, the Supreme Court, they are getting the written record. They are not getting the video. So they're not going back to be able to say, wait, no, actually, it wasn't a lunch break. This was a take off your shirt break. Get your clothes in order, their witness. That turned into, we need more time because something else is going on. Okay, Your Honor, we'll take your
recess.
We'll take your rewrite. I guess, every judge and every attorney is very colorful with their words. That's a part of their creativity.
It's on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m.
11:52 to 12:51. So we're just glossing over an hour? Wait a minute.
In courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m.
Okay. Okay. 11:51 a.m. So this is the way I can take this. I don't know if this is exact because I feel like the judge is being colorful with the record. But anyway, I think what he's stating is much to what the defense said. They were supposed to be there at 9 a.m. or, be there at 8:30 for a 9 a.m. start. But what he's reading is just the record of how the flow of the day went. He's obviously not reading the testimony. So he's saying that they actually took record at 11:51 a.m. and then an hour later they went to lunch. Okay, so I don't know if this has to do with the sweater or not. I'm not following the judge in the timeline, but we'll just proceed.
The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams.
How colorful is that? I mean, truthfully, the law is meant to be concise and poignant. It's step to step. So this is a very chronological order, step to step. But the details of it all is just washed away real easily. And we remember, quite honestly, it was a whole lot more than he was held in contempt. You know, there was reasons, there was Ashley Merchant coming in with the task force. Like, it was a lot going on.
The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time.
Really? Okay, Judge. So the judge is stating that he wanted to know who the snitch was. He wanted to know who or how the information was obtained, because it was more important to find out if something was received improperly, if the information was received improperly. And it was the first concern, whereas the second concern of if the information in ex parte hearing was proper or not is secondary to finding out the first concern, which was primary, is if the information was received improperly. But how are you the honor, the judge, that can be the person to witness the improper communication or to decide if the communication is improper or not without disclosing as such to the defense prior to the hearing or after the hearing that you had an ex parte meeting, and to turn around and say you needed to know if the information was received properly? It goes back to, you should have a colleague review and have an actual hearing relative to that motion so that it can be determined if the ex parte appearance was warranted, if it was without issue, and consequently, if someone was a whistleblower or if someone was improperly informing the defense of things that they should not have known. So it's hard to say. It's like, what comes first, the chicken or the egg? What comes first? They kind of both are tandem. So that's why having the hearing would have been much more appreciated, in my opinion, because if the information in the hearing is improper, if that information is a Brady violation, if that information is coercion, if that information is threatening the witness in any way, or giving the witness the feeling like they have no rights and they must do something without giving them an understanding that they don't have to, that they still can maintain their Fifth Amendment right. If somehow you feel like the influence of the judge has put the witness at an unfair advantage, you find this out, third party or direct party or whatever, why do we have to find out how this information was relayed versus determining if the information is correct? To me, it's almost that's first, because if that information is correct, and then you find out the information was relayed by one of the attorneys that was in the room, or anyone that was in the room, they're being a whistleblower. So they're protected by whistleblower protections. So you don't have the right to find out who told you or told Ben Steele the information until you figure out if the information should have been told to Ben Steele. So once again, is it the chicken or the egg? Which one comes first? The court says he wants to know
those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time. Jurors were Mr. I'm sorry. Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The
There's a materiality missing. You put Mr. Copeland back on the stand, right? Wasn't he back on the stand during that time? So why don't we say that he testified?
court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court has already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record.
So instead of him being able, here goes that art again, the art of the English language, because the judge is going to paraphrase the 6 assertions. Why? Why are you paraphrasing it? Because the court record is not clear, because the judge kept cutting Mr. Steele off, because every time Ben tried to make a record with the court, the judge would only ask, who told you, who parroted that to you? I'm only concerned with who told you. And he continuously interrupted. So the judge can only paraphrase, because otherwise, if he tried to articulate exactly what Mr. Steele said, there would be nothing but interruptions throughout all of that day when he was trying to get the record clear. All right, well, let's see what the paraphrases are.
The first one,
which I don't know any word assertions. I think all of them were inquiries, but the judges now paraphrase that into identifying, categorizing them as assertions. I don't think Ben asserted anything. He kept saying, this is what is told to me. We need to find out if this is true. Based upon your response, it sounds like it's true. We hope this is not, but we need to have a separate hearing to find out if it's true. So those are not assertions, those are inquiries, but okay.
Involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present.
It's a rewrite. That does not paraphrase what Ben said. He didn't say that Copeland and his counsel met together. Maybe he's saying all of these people met together. But the question is, did you guys have an ex parte hearing? Okay, okay. All right, words matter. Okay, let's go back.
Sheriff and deputies, Mr. Copeland and his counsel.
I don't know, because sheriff and deputies, were they there part of the meeting, or were they there part of bringing the witness, securing the room, securing the judge, or were they actually a part of the meeting? But okay.
Met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
What? You, okay, that was on Friday. Copeland said on the stand, okay, I think I know what the honor is saying. So on Friday, Copeland said, I plead the Fifth. That halted the conversation on the stand. He said, okay, after the weekend on Monday, we'll come back and we'll find out from the witness if he's actually going to testify or continue pleading the Fifth. And then the DA requested a ex parte meeting, kind of, I guess, instantaneously when they got there. And I'm not sure it's the timeline as to when the ex parte hearing was requested, but they met in his chambers. In his chambers were those individuals. And so what he's saying is, because Ben says that it was stated, I think Ben said this in court, that it was stated to him that he, got the information and believes that this information is true, that the witness who already pled the Fifth intends to continuously plead the Fifth and to not be a witness on the stand and does not intend to testify. I think that's what the second assertion is about. It's relative to the second pleading of the Fifth, not the first one when he did on the stand. Okay,
third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present.
That is a lot to put in one assertion. Usually you break it down. So one, he's a sworn witness. Well, that's easily verifiable. Second, critical part of the state of the trial. He's one of the critical witnesses that say that the defendant killed the gentleman. So I don't know about putting that all in one assertion. I would break that down, but Your Honor has it collective. So there it is.
The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas.
Okay, so his third assertion of Copeland's going to plead the Fifth, meaning he's going to continuously plead the Fifth, is now coming back around, I guess, in the fifth assertion, that in response to that, ADA Hilton and the judge, which he doesn't say the judge, he just says Prosecutor Hilton, I think is what he says, has influenced the witness, intimidated him, and coerced him into testifying. The sixth one is that he is in fact the actual murderer of the person that they're trying to clarify who murdered or ordered the murder of. Okay, so those are the six, but I want to go back and see that fifth one again. I want to hear that.
Copeland not going to testify. The fifth group involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness.
Wait a minute. Hold on. I'm still trying to hear this one word, this one phrase.
Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation.
So, okay. Interesting. So the judge has worded this order for this assertion, his paraphrase thereof, that Hilton, ADA Hilton is the one that is speaking, but yet the coercive or intimidation activity that's going on, the defense is asserting that it includes the court. And it's very artfully put there versus saying ADA Hilton and the court participate in coercion and witness intimidation. He words it differently to include the court. Well, the court was automatically included because they're there. The question is, did the court participate? Did the court influence in some way? So the assertion is really an inquiry, in my opinion, but he's saying assertion. Assertion number 5 is so well crafted, it's almost to say the court was in the building. It's like, yeah, the court was in the building. We were in your chambers. They were in your office. You were there. So it's not a question of, were you there? The question is, did you hear what was said? Were you a part of what was said? In fact, did you pass out paperwork? Were you, did you participate in the actual witness intimidation process that, for which the defense thinks is intimidating the witness?
And that his counsel had the right to be present. And the 6th assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas.
So there goes, that answers my question, because that assertion that Ben Steele stated, that particular inquiry, he said when the court was off the record, when the court was at recess for lunch. Oh yeah, he did say recess for lunch. He did. Okay, I remember the lunch part now. So the lunch part comes into play, but that was after Steele was making his motion for inquiry. So anyway, they went to recess. I would go back to that timeline. I think that chronological timeline is off, because they went to recess when Steele was trying to make a record of the issues, and he wouldn't tell who was the source. And that was the only question the court had, is who's your source? Who told you this? How'd you come about this? There's only 2 ways you can come about it, unless you're listening at the door. The other way is someone told you. Who told you? Tell me who told you. And in all of that encounter, the judge says, I'm gonna give you some time to think this over. We're gonna go to recess to think this over so that you can decide, if you can take this as a serious matter, decide if you're going to ignore the court's question, because Steele kept saying, I'm not telling you. But what I will tell you is, according to this, according to that, this is what we think, we want to know, but I'm telling you. Each time he tried to respond, that's when the judge kept interrupting. So there's no clear record as to what the assertions or inquiries were until after the motion to recuse is put on the table by Weinstein's client. But right before, I remember, I don't know if you saw the video, if you didn't, go check it out. Right before they go to recess, right after the judge says, we're going to take a break, we're on recess, that is when Steele says, and it's further told to me that that Copeland admitted to killing Mr. Donovan, Thomas or Taylor, whatever his last name is, Jr. And that's the victim of the trial. And so I wondered, since he said that information right after the judge put them in recess, would that actually be in the transcript? Because typically when you're in recess, you're no longer on record. So I, parsing hairs here, was it actually on record that Steele put the fact that Copeland admitted to murder? I don't know. I really don't think it was, because when the judge put him on recess, there's no record after that. Record is done usually with the court reporter. So that's an interesting thing, but he has it here in this order. He took it up as a part of the record in the order.
At some point after Mr. Steele was held in contempt by this court, in the afternoon of June the 10th was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court
So video in the hallway gives the court, but why is that of record though? Are you gonna put the video? Are we gonna place the video as a piece of evidence? So now the record is reflecting that in the hallway, those individuals were talking with one another. Okay.
court in no way sought to investigate any facts of this involving this footage, and it only considered it for the security and timeline of events that occurred on June the 10th of 2024.
Well, did you have a hearing about what was the exchange amongst these officers of the court? Attorneys are officers of the court. So did you have a hearing about it? Because I think the whole fight is to have a hearing about it.
Also, in no way did the court consider any of this footage
With a different judge.
in holding
That's
Mr. Steele in contempt. And as I
Wait,
said,
what?
mentioned.
Wait.
Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt.
Okay, so the court is just stating that though there's some evidence that points in a certain direction unknown to them, truthfully and honestly, they don't really have much to do with that particular evidence. They haven't investigated it. They don't really know the contents of it. They don't know the sum and substance, as he likes to say. But it was not in consideration of holding Ben in contempt. It was the exchange in front of the court that put him in criminal contempt. Okay.
And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's
Oh, look,
chambers.
it's
not
actually
for
in the
the-
building. This is the gentleman that was with Ashley. I'm so sorry, sir. I don't know your name, but he's the president, I think, he's the president of the task force, and Ashley is on the board and the president of the bar association, I believe. Let me see if we can find it. Okay, so we have Georgia Task Force, which their name is not just Georgia Task Force. What is it called? It's the attorney. Is this Chris? Oh, no. That's the AG. That's Georgia's AG, is Chris Carr. Georgia Lawyer Competency Task Force. I don't think that's the actual name. All right, let's pause for a moment. Okay, so it's the strike force of Georgia Association of Criminal Defense Lawyers. Can't think of his name, can't find his name. So sorry, it's so rude. When I find it, we'll talk about it. But nonetheless, maybe Ashley Merchant's on the other side of him, and she's the president of the Georgia Association of Criminal Defense Lawyers. Okay, moving back into
whether or not that was truthful or not. Security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024.
You just listed six.
One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was, the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness and this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9.
Okay, we're getting some authorities. Okay, Judicial Code of Conduct 2.9.
Which the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any or procedural, substantive, or tactical advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it.
Hold on. I'm sorry. Today is July 1st. This happened June 10th. You think that's prompt and reasonable? How many days and hours of testimony has Copeland given past this ex parte? What?
So everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit and before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had and the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. Decided in 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contended the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations the trial judge may find an ex parte conference necessary. They cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. They say C, United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1150. Ural versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got a citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, Um,
So that was a whole lot of convo, right? Great, Your Honor. When were you planning on disclosing this ex parte hearing? Today? July 1st or 2nd, whenever the package can be put together, whenever the court reporter can finalize the transcript? How is that prompt? How is that okay? So all of the stuff he just cited, it was like, great, you just proved the issue that the defense had, is that they weren't promptly notified. They weren't notified at all. One of the defendant attorneys got in when I said just join in, everyone's just joining in, just say, you know, defendant so and so joins into the current motion, unless you have something to add, because some people were just repeating the same motion. And so one of the gentlemen on the side with the gray hair, he gets up, he says, you know, gray beard, he says, you know, in addition to the motion, I wanted also to be very clear, we were never notified that there was a hearing, an ex parte hearing. We weren't notified while we had to wait. We weren't notified after the fact when we got back. You know, wasn't notified beforehand. It wasn't notified before we started court. And still asked, how do we get the defendant from going from pleading not guilty, from pleading the fifth to coming and saying, I'm going to testify. So the attorneys did a great job of getting the record. Hopefully the record is clear, because there was some artful paraphrasing by the judge. So hopefully the record is precise. But the attorneys did a great job of putting certain contentions on the record to state, one, we were never notified prior to or thereafter that there was an ex parte hearing. And in fact, the information that we received, we weren't sure what that was. And you, Your Honor, in open court expressed it was ex parte hearing, but you know, we just know you guys had a meeting. We don't know what you guys were talking about, and we don't know what kind of meeting it was, because no one gave us the notice, and we never waived our right to a notice or never waived our right to be present. So, so what did he just do? Great. He just exclaimed why they should be upset. So tell us what happened in the meeting.
the only thing discussed between the state.
Oh, here is what he does say. He says that the ex parte meeting was to go over the immunity agreement. I mean, why do you need the judge's presence to go over an immunity agreement? The immunity agreement is done with the attorneys. What does the judge's presence, why does he require necessity to go over the immunity agreement? And the immunity agreement is not, it's not a secret to the defendant. So it would have been filed in open court and would have been public notice, but the prosecution asked the judge to put it under seal. So the order to put it under seal has, I believe, been signed, but the immunity agreement, the immunity deal was going to be filed on the case. And it was going to be, and it was supposed to have been given to the defense. The defendants asked for when they came back from trial, where's the immunity deal? We don't know what immunity deal he has. Where's the agreement? So you are saying that the ex parte meeting that had to be hush hush, or at least without a party, didn't require the defense, was to go over the immunity agreement with the witness. And that it was the immunity agreement that they were talking about. Was a part of that agreement anywhere, well, if you lie, I won't prosecute you? Is that a part of the immunity agreement negotiations that was asserted? Or if you do lie and say that you're the killer of Donovan, or if you say you're the killer of Donovan, whether you're lying or not, I will prosecute you, which was a part of Weinstein's affidavit relative to the motion to recuse, that the information given to them by whomever, this is a part of the conversation. So you are putting this under, this was a conversation about the immunity agreement. Okay, but US versus Adams, and according to the reading by the court right now, is to protect the witness when the witness has been threatened or feels like there is a threat upon them. How to protect them is when you have an ex parte meeting with a witness. Not sure what that has to do with an immunity agreement, because that's with attorneys. What judges needed for that? I don't know.
Count.
Let's hear what you have to say.
The only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced.
There were no facts. We don't know what his testimony was, so I guess he did admit to killing Donovan, I guess is his point.
Or sought by the court, and the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical state. Right is the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the 6th Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on look at the case law, that this was a proper ex parte meeting pursuant to Rule 2.9, as well as the no party gained any tactical advantage, and that the proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants.
Okay, so I'm with Adams. Adams had Adams proclaimed and professed that he didn't want a clean transcript. He wanted the rough. And the rough is a precise term. It's like whatever the court reporter types at the time of the hearing, that's the rough draft. And consequently, what court reporters will do is take that rough, put it into the right format, go listen to the recording and make sure that the words are relayed properly and synced. Well, depends if you're doing civil deposition. I don't think that they sync them relative to the criminal court. You guys can let me know. but for deposition, they will sync the wording and make sure that when it plays at the right time. I don't think they have to do that for this because this is just the transcript of the hearing. So there is no audio playback. But he wanted the audio too. He's like, I want the playback with the audio. I want the rough. And the judge still today is like, okay, so when she's done putting the order together and putting the transcript together, you'll get it. You're going to get it. You're going to get it. And this happened, I think it was the 10th day of June. So we're in July 1st. This 2 weeks plus ago. And they still don't have it. That's a long time in trial days. It's a very long time in trial days to be waiting for information to know if it's critical or not, to know if it helps or not. And he's stating that no party gained any tactical advantage because that's a part of why an ex parte would be improper. Well, I don't know about that, Your Honor, because if the defendant is a sworn witness on Friday and he has pled the fifth on Friday, meeting with the defendant over an immunity deal with the judge, which why the judge's presence is necessary is still quite unclear considering it was only over the immunity agreement, which is made by the attorneys. So meeting with him over the immunity agreement in ex parte as a sworn witness, and now he comes out ready to testify, does not give them a tactical advantage. Seems like the prosecution gained a tactical advantage with the witness willing to testify. And on top of that, later, ADA Hilton proclaims, oh, he's not a cooperating witness. You see how hard I have to work to get him to answer the questions. So consequently, when I'm getting him to answer the questions and he's giving me a fight, he's clearly not a witness of my side. Okay, I'll be right back. Sorry, you guys. Sorry, I had to take a phone call, so I'm back now. But as I said, the judge is representing that there was nothing nefarious of the ex parte hearing, of course, and that the desire and necessity for the defense to be promptly notified is now occurring because it could not have occurred sooner because we didn't have the recording, and the transcript will be presented to you in short order as soon as she's done putting everything together. And consequently, if you just would, wait your horses and pull your horses, you pull your jets, you'd be okay because you'd get everything disclosed to you in a proper time frame. Okay, Judge. And that the testimony of the transcript was not testimony that would give a tactical advantage to the prosecution and therefore be detrimental to the defense. So this is the reporting of the judge relative to the ex parte. And okay, I don't know how much we believe, but this
Are
is
released will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Steele's raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding, which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge. It is well settled under the Georgia Constitution guarantees a criminal defendant the right to be present and see, hear all the proceedings in which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia, 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome and if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow.
So the judge is saying if your right to be present will contribute in some fashion to the procedure, then you must be present. But in ex parte hearing that doesn't give you any contributing factors, then your right does no longer extends to that time frame. So you don't need to be present as a defendant or the defendant's counsel. And so the judge is stating that since the ex parte appearance was relative to the immunity agreement, there's nothing that the defense counsel can contribute towards his immunity deal. That's actually a deal between him and the prosecution, and the only other contributor would be his attorney, which brings me back to why are they meeting with the judge? But his bottom line is the context of the actual meeting did not require defense to be present because they did not have a contributing factor. And this is one of the ways of defining critical stage, a critical piece of information. So the judge has already stated that Copeland did not testify to anything. It was relative to the immunity deal. So the assertion, AKA inquiry, of did he admit to the murder, supposedly is wrong. He did not, according to the judge, and the record should bear the truth of the matter. This is what he's saying right now. Oh, and consequently, it wasn't a Brady violation, so therefore your rights are still preserved and you weren't needing to be there as a defendant. This is what the judge is saying, and a whole lot of legalese and a whole lot of authorities, because he's citing a lot of case authority to back up what he's defining and determining what is proper and improper. But I wonder why he is ignoring the fact that it has been relative to the comment on the Rule 26, it has been determined that it's better for another judge to have such hearing and give such order, not the same judge. Like the same judge cannot determine its own actions to be proper or improper, that it should be a different judge to do so. That's another point. We'll see. The wheels of justice run slow. Run slow.
The court further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and or our Supreme Court. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this, along with the attachments, will be included in the record. And Mr. Banks, where are you? Sir, as a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. And as I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that. So we will not be holding that particular hearing, okay?
So the order to show cause. Yeah. The abuse of power for the order to show cause has now been indefinitely withdrawn. No need to appear. And the court is not taking up the issue of Attorney Burgess's supposed parroting of the ex parte hearing. One, because no one has testified. There's no evidence that really explains that she is the one, not in court anyway, that she is the one who informed the defense of anything, let alone parroted the whole ex parte hearing to the defense. And he's saying, we don't take any issue with it. We will allow the bar to determine. So I don't know if he's going to submit to the bar of Georgia, but what that will do is put on a hearing before the bar to determine if she was being a whistleblower, or if she, well, one, if she did do it, two, if she was being a whistleblower, or three, if she had the reasonable thought to be she was being a whistleblower, or four, if she violated her attorney's right to attorney-client privilege. So her attorney-client privilege is what the judge is saying that she may have violated, and he's going to let the bar take that up. And what he did was he put in an order for all the persons in the room, order to show cause why all those persons were not the ones who were the parrots, who were the snitches. And so since he's narrowed it down into believing that it's just Burgess that has been the snitch, no one else needs to show, that order to show cause is no longer a hearing. I wanted to see who was going to show up, though. I wanted to know who was going to come to the order to show cause hearing. Don't cancel it. We got to see who is ballsy enough to ignore the judge and say, nope, I won't go.
All right.
Now everybody's off the hook.
And then then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it, and until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until they're not supposed to come back on Monday, until Monday anyway. So I will.
What?
I will have.
What you say now, Your
transferring it, this in manner prescribed by our court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it. And until such time as those two things are decided, then we'll be in recess until that time. And we will.
Okay, so did you hear that? Did you hear that? Huh. I wonder if Judge Glanville has had some conversations that would, in fact, be in sacrosanct of his chambers to speak with other other judges, and read over the law. But when he was hot and heavy and upset, it was like, I'm not recusing myself. I'm not selecting another judge. We're not slowing down this trial. We will not take a pause. I'm not listening to you. All that hoopla, all that friction, all that, you know, and and in the quietest, straightforward voice, level-headed tone, without much to do about nothing. If you didn't know anything else was going on behind the scenes, or not even behind the scenes, that happened a couple weeks ago or a week ago, you would think, oh, okay, the judge is just okay. He's going to do the right thing. He's letting another judge go ahead and look this up, and and take care of this case, and try the hearing. And once they're done, then we'll get back to court and see what's up. Either I'll be the judge presiding or I won't be. You would think there was of no issue, but in fact, it took us a long road to get to this place where Ben Steele was standing very firmly on the fact, him and Weinstein alike, very firmly on the fact that, Your Honor, you cannot preside over this. We need a different judge to preside over it to ensure that this is right and proper. You cannot decide for yourself. We can't just take your word on it. It has to actually go through a hearing. It needs to go through a hearing from a different judge. And here we are, in less than 2 minutes. It's stated as such. The judge is transferring this matter of recusal over to a different judge. And since they're in recess anyway, the jury gets back when they get back next week. Hopefully we'll have that matter solidified, and we can get back to business.
We'll just inform our jurors that they're until this is, they're not supposed to come back on Monday, until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point in time. Okay?
Okay.
All right. Ms. Novi, can I ask you a question before you start anything? Madam, didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual or perceived conflict in this case? No. How did you? Didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual or perceived conflict in this case? No. How did you? Have you been? I'm asking you this.
So.
Point in time, could you state for the record how?
Let's go back again.
Start anything?
Sorry.
Madam, didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual or perceived conflict in this case? No. How did you? Have you been? I'm asking you at this point in time. Could you state for the record how it is that you don't think you have a conflict, because you did represent one of the co-accused in this case, correct?
I did.
Okay.
I did. He's been discharged. Your Honor, this has absolutely nothing to do with my representation of Sergio Kitchens. Haven't even discussed that or come up, and what happened in the Ex Parte proceeding. We're just representing Mrs. Bumpus, Attorney Bumpus, in what her position is with respect. Is on mute?
Yeah, you're good now. Yeah.
With respect to this court. So completely different matter, and now we're dealing with a contempt hearing of Miss Bumpus as opposed to a criminal prosecution of Mr. Kitchens. Completely different, and in fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with Attorney Bumpus.
Okay, I just want to, because you may have an actual or perceived conflict. I just wanted to bring that to your attention. So if you think that it should be addressed, then I'm giving you the opportunity to do so at this point in time.
No.
Because you do have knowledge of this particular case, but, all right.
Well, I
But
think
what
half
el-
of
what else-
America
I'm
has
sorry?
not. I said I think half of America has knowledge of this particular case at this
Well,
point.
okay, but they're not before us at this point in time. So what
Now-
else did you want to?
Well, and I'll speak for the court's purposes. I'll speak for myself and John Garland, who's also our co-counsel with Attorney Bumpus and who was my co-counsel in Mr. Kitchen's case.
All right.
So I'll speak for both of us in that respect, since Mr. Garland's not able to be here.
All right.
A couple things that I just wanted to clarify for Your Honor. Is the court still intending to produce an order on what the court addressed orally on our recusal motion?
Yes, ma'am. I'm going to produce an order basically bundling all, since there are 3 motions to recuse, to one, to be spun on the wheel so that we don't get 3 separate people hearing these particular matters. So I will do that effective today.
Okay.
So does that answer your question?
It does with respect to that. The other issue was I think the court was holding under advisement our motion to quash.
That makes this moot at this point in time.
Okay, so
Since I'm not going to have a hearing at this point or at any time in the future, you can re-raise it at that point in time if you show desire.
That's fine. So we'll
But,
just
but
leave it.
I'm telling you, at this point in time, I have no desire to resolve that. I don't need to at this point in time.
Okay. All right. Those are the questions that I had.
Okay, all right. Madam, unless you have anything else, you all can be excused.
Okay, so let's just kind of clarify what just transpired. So this young lady didn't get her name. She's representing Attorney Bumpus, which is stated to be the young lady who parroted or informed Brian Steele, I keep calling him Ben, Brian Steele and crew about the ex parte hearing. Interesting enough, if she is the one who did so, some of the things that were informed upon were Brady violations. So it's going to be a very interesting piece to find out what comes out of all of this. But so she is going through a contempt hearing, I guess, is what this attorney just represented, and she's representing Madam Bumpus in against the attempt hearing, which would be most likely, it sounded like the judge was actually having that brought before the Bar Association in and of itself, so not in his courtroom, but a hearing with the Bar of Georgia to see if her license will be revoked, suspended, or some other resolve. Further, he wanted to clarify if that particular attorney who just stepped to the microphone has represented another defendant in this case, why is there no particular conflict of interest for that attorney to represent Bumpus, who is an attorney for the witness, Copeland? Interesting, they don't determine it to be a conflict. And mostly I think it's just not a conflict because the hearing about Bumpus is relative to her whistleblowing, is relative to her potentially not protecting the rights of her clients and divulging attorney-client privilege information, because it is the judge's contention that certain things that may have been expressed to the defense did not happen in ex parte hearing and may have happened at a different time. So if it happened at a different time, it would be covered by attorney-client privilege. If it happened at the ex parte hearing, the judge may still want privilege to be held up, just because if that happened during the ex parte hearing for which that attorney and that client were talking about his immunity deal, and elements of his immunity deal was to not be tried for the murder of Donovan, it would take his ability to be honest and upfront with his attorney to determine if that's a necessary exemption to have within his agreement. So there's a lot of tangling webs right about now as to what lane this is actually going down. It's going down many different curved roads, and we shall find out hopefully sooner than later. I don't know if the Bar Association is going to take up the hearing quickly or not against Ms. Bumpus. And I'm sure that whomever the judge transfers this case over to try the 3 motions to recuse, that they're going to take it up quite quickly so that they could probably get through it within the next week, so that the jurors can come back to court closer in time to their expectation, which is next Monday. Even though the 4th is a holiday, so I'm not sure that they actually have a whole week to go through the motions to recuse, but nonetheless, the judge has read the law and he's in agreement. Another judge gets to decide. He does not, him himself gets to decide by himself. He needs to send it to another judge. Ole, ole, ole.
Councils, I'm going to go ahead and, like I said, work on this particular order. I actually memorialized the order in writing and the motion to recuse in terms of the sending it to another judge pursuant to 25.1 through 25.7. And we'll see in a little bit, depending upon how it's ruled upon, all right? All right.
Your Honor, do we have a timeline of when the motion to recuse may be heard?
Don't know. That has to go to another judge pursuant to our local rules. Yeah. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Miss Alexander and her team spin that, that's not within my information and purview.
Is this something that we can expedite? I mean, the state does have very concerns that we hold the jurors indefinitely regarding this matter. Is there anything that could be expedited so that those decisions can be made on the motion to recuse and we can move forward with the trial?
Well, I understand your concern. I think the rules of transfer and recusal are pretty clear. That I'm not going to comment on anything that is pending at that point in time. So hopefully it will get done fairly quickly in terms of somebody acting on it. Okay.
All right, thank you, Your Honor.
Okay. Anybody else? Mr. Steele, you rose just a second ago. Did you want to say something, sir? No, I thought you were recessed. Okay. All right. Okay. Okay. Then we're in recess, and we'll see you in a little bit. Okay. All right. We're in recess.
Okay, but in recess indefinitely, no? No, we're not coming back, are we? I thought we were transferring the motion to recuse. So no, because the jurors are out. They still want to work, I think, equally. What is going on? A lot is going on. A lot, an absolute lot. So that was relative to our ex parte, and they went into quote unquote recess. But I don't see them coming back from recess. So I believe the recess is still the relative that they're paused until they can get the outcome from the other attorney on the motions to recuse. So that, I think that's it on that. So anyway, let's do a little bit of our research. So we need to come up with what was the rules that the judge just ordered upon. So Georgia Rule 25.1 was the start of it. And he went all the way to 25.7. All right, well, let's see about it. Come on down to research land. We're gonna see what we have here. Oh, I can't see. All right, all motions to recuse or disqualify a judge presiding, which means overseeing, in a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall fully assert the facts upon which the motion is founded. They did that basically the same day, so they definitely did it properly. Filing and presentation to the judge shall be no later than 5 days after the affiant, the person who declares, after the affiant first learned of the alleged grounds for disqualification, and not later than 10 days prior to the hearing or trial, which is the subject of recusal or disqualification, unless good cause be shown for failure to meet such time requirements. In no event shall the motion be allowed to delay the trial or proceeding. Okay. How do we get to the next one around here? Oh, let's just do the whole. Okay. So the affidavit. Affidavit shall clearly state the facts and reasons for the belief that bias or prejudice exists, being defiant and specific as to time. So you're going to be definite and specific as to time, place, persons, and circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of any adverse party or prejudice towards the moving party in particular, or a systematic pattern of prejudicial conduct towards persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. Allegations consisting of bare conclusions, I'm gonna words. Allegations consisting of bare conclusions and opinions shall not be legally sufficient to support the motion or warrant further proceeding. Well, the affidavit has opinions, obviously, but it has actual facts, for which I don't know how much is actually contested, because the judge was in the very beginning was like, that was an ex parte hearing. How do you know those particular facts? But it looks like he contests the fact. The one fact that seemingly is the theme piece of information that he believes is not a part of the ex parte is the one where the sixth assertion where Copeland admits to being the murderer. I believe that is the fact, if not more, that the judge says did not happen within the ex parte, based upon the way he was reading the rulings for why an ex parte would be problematic or not problematic to have when it's with a witness. All right, the duty of the trial judge when the judge is presented with a motion to recuse or disqualify accompanied by an affidavit, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit and make a determination, assuming any of the facts alleged in the affidavit to be true, whether recusal would be warranted. So assuming that any of those facts are true, you're supposed to stop immediately. You temporarily cease acting upon the merits of the matter, and you immediately determine the timeliness of the motion and the legal sufficiency to have that motion. Legal sufficiency was a part of the 25.2 where the affidavit has to state more of factual things, not opinionated stuff for recusal. So, in all intents purposes, the motion for recusal at its time was timely and it had legal sufficiency. So if it is found that the motion is timely, the affidavit is sufficient, and that recusal would be authorized if some or all of the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. The allegations of the motion shall stand denied automatically. The trial judge shall not otherwise oppose the motion. In reviewing a motion to recuse, the judge shall be guided by Canon 3E of the Georgia Code of Judicial Conduct. And I think, he did 2.9. This one says guided by Canon 3E. Let's see. This is former rule 25.2 renumbered as 25.3 and amended effective 1991, amended effective 2005. Okay. Okay. Let's see if we can get through these. Procedure upon a motion for disqualification. The motion shall be assigned for hearing to another judge who shall be selected in the following manner. If within a single judge circuit, the district administrative judge shall select the judge. If within a two-judge circuit, the other judge, unless disqualified, shall hear the motion. If within a multi-judge circuit composed of 3 or more judges, selection shall be made by use of circuit's existing random impartial case assignment method. If the circuit does not have a random impartial case assignment rules, then assignment shall be made as follows. The chief judge of the circuit shall select the judge within the circuit to hear the motion, unless the chief judge is the one against whom the motion is filed, which we know he is the chief judge. Or in the event the chief judge is the one assigned, the judge is the one against whom the motion is filed, the assignment shall be made by the judge of the circuit who is most senior in terms of service other than the chief judge, and who is not also a judge against whom the motion is filed. So they must have a randomization procedure. It sounded just the same because the chief judge Glanville just stated once they put it on the wheel, and then whatever judge is selected from the wheel, that will be the one who will oversee these motions, and that they will oversee all 3 motions to recuse. They're not going to just do one. We'll have it as one collective so that the outcome can be decided by the one person, and we can just move along as whatever the outcome is. So that expresses that they do have something to randomize the assignment of the case. However, in the event they don't, and obviously his name has to be off the wheel because it's against him. But in the event they don't have that type of impartial randomized assignment process, then it says you would go to the chief judge. If it's against the chief judge, then you would go to the next senior judge. So you would do it in accordance to seniority when you have a multi-circuit judge. You have more than 3 judges in that district. When the motion pertains to all active judges in the circuit, the district administrative judge shall select a judge outside the circuit to hear the motion. Okay, that's not relative to this, of course. If the district administrative judge is the one against whom the motion is filed, the judge within the district senior in time of service or the next senior in time of service, if the administrative judge is the one senior in the time of service, shall serve in this selection process instead of the district administrative judge. Okay, so that's not pertinent either. First, because it doesn't need to go to the administrative judge because they do have a randomization. But if that was against that judge, it would just go to the next senior judge. That's what it's saying. If all judges within the judicial administrative district are disqualified, including the administrative judge, the matter shall be referred by a disqualified administrative judge to the administrative judge of an adjacent district. So if it was against all judges in the same district, it would go to an adjacent district for the appointment of a judge who is not a member of the district to preside over the motion or case. If the motion is sustained, the selection of another judge to hear the case shall follow the same procedure as outlined above. Basically, randomize if you can, as long as they're not named. If you don't have a randomized procedure, then it goes to the next senior person that is not named in the motion. That's the basic outline. In the instance of any hearing, this is selection of judge. In the instance of any hearing on a motion to recuse or disqualify a judge, the challenged judge shall neither select nor participate in the selection of the judge to hear the motion. So Judge Glanville, he cannot select, he cannot participate into who is selected to hear the motion. If recused or disqualified, The recused or disqualified judge shall not select nor participate in the selection of the judge assigned to hear further proceedings in the involved action. So if in fact he is recused, he also, even though he's the chief judge, will not be able to participate in selection of who gets to hear the motions and the rest of the case moving forward. All right, 25.6 findings and rulings. The judge assigned may consider the motion solely upon the affidavits, but may, in the exercise of discretion, convene an evidentiary hearing. So this is where that tape may come into play, the recording that he put on the record. There is a recording for which is not considered by Glanville because he cannot consider that because it will be a part of the motion to recuse. And so that particular judge will, upon their own discretion, be able to do an evidentiary hearing to decide upon what evidence is in fact relevant, prevailing, and accurate. Otherwise, the motion can be just based upon the affidavit, which was Weinstein's affidavit. After consideration of the evidence, the judge assigned shall rule on the merits of the motion and shall make written findings and conclusions. If the motion is sustained, the selection of another judge to hear the case shall allow the same procedure as established in Rule 25.4 above. Any determination of disqualification shall not be competent evidence in any other case or proceedings. Well, that's good. So that's to say, if this attorney is disqualified in this case, it does not affect in any other proceedings that have ever transpired, any other cases that have ever transpired. So it doesn't come into question as to, which I thought it might, that it could, but it doesn't. So it doesn't come into question. You can't use this and say, oh, he's a bad judge, and so every case is now a problem because he's a bad judge, just because he was recused. Now, 25.7, voluntary recusal. If a judge, either on the motion of one of the parties or the judge's own motion, voluntarily disqualifies another judge selected by the procedures set forth in 25.4 above, shall be assigned to hear the matter involved. So this judge can voluntarily recuse himself on his own motion, or he can look at the motion to recuse and say, you know what, you're right, I should be off of this case. And in doing so, another judge would be selected based upon the randomization that was put forth in Rule 25.4. That's what that says. A voluntary recusal shall not be construed as either an admission or denial of any allegations which have been set out in the motion. So to recuse oneself voluntarily does not admit nor deny. It has nothing to do with that. It's just choice of recusal. So that was Rule 25. The recusal, this is the Rule 25 is the rule that has now been the authority to have Judge Glanville transfer this case to another attorney. All of this, he cited 25.1 through 25.7. All of those subsets were a part of what he cited. Now, he did judicial conduct. Okay. Okay, so the judge went off of judicial conduct 2.9. So canon 2, I want to see canons. I want to see 3. Judges shall regulate their extrajudicial activities to minimize the risk of conflict with their judicial duties. Okay. Defines the characteristics, accepting appointments. Okay, so this is like outside of, like, gifts. Yeah, this is outside of the courtroom, conduct outside of the courtroom. So I was wondering what Canon 3 was about, because that was referenced in one of the one of Rule 25's subsets. But what the judge noted was Canon 2.9, and this is ensuring fair hearings and averting ex parte communication. And you heard the judge say, I I'm taking judicial notice of this and I'm taking judicial notice of that. That just means it's an evidentiary fact without having to go through the fact finding process, I guess. So judicial notice is a rule of law of evidence that allows a fact to be introduced into evidence if the truth of the fact is so notorious or well known. So that's judicial notice. It's the judge being able to say, look, I'm taking judicial notice of this. We don't need to argue if this is true or not. This is a well-known fact, and we're taking judicial notice thereof. So what I wanted to look at was I don't know what I wanted to look up. All right, well, let's go ahead and get into Rule 2.9 because that was what was cited by the judge. Okay, so assuring fair hearings and averting ex parte communications, judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to the law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or an impeding matter, subject to the following exceptions. Okay, so basically judges will not have ex parte hearings when we are currently in trial, except under these circumstances. Where circumstances require ex parte communications are authorized for scheduling, you heard him say that, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of ex parte communication. Wow. And the judge shall make provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. So there's this beautiful language here. It's 3 letters. And this little bitty word here is very powerful. It's very powerful. I have one argument based off of this 3-letter word, the word and. It's one thing, another thing, and another thing. And I have one argument just because of the word and. So the exception to a judge holding an ex parte hearing is where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies. So either one of those things. The emergency in this matter is having a witness not willing to testify. And then what they said was he needed clarity or some kind of conversation on his immunity deal. Not sure why the judge has anything to do with that, but that's the emergency. He was resting on the word emergencies when he was putting his order forth just now before us. Okay, so these circumstances allow for ex parte that do not deal with substantive matters or issues on the merits. So it's not substantive, it's not an issue merit to the case. Only provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. Well, the judge said there was no tactical advantage. but was there a substantive advantage? I think there was a tactical one too, but was there a substantive one? He didn't address that. And in addition to that, he believes that none of those things will occur. And the judge makes provision to promptly notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. The parties still don't have the sum and substance of the ex parte. The parties still don't have the record. And today's July 1st. This is July 1st. This is real time right now, July 1st. However, the hearing and the hoopla was June 10th. That's when Brian. That's when Brian still was like, no, we must find out. Did this happen? Because we're confused. We're told, but we don't know. Did this really happen? So was that a prompt notification? Because they were in trial. The witness was on the stand. Before the witness took the stand, they asked, how do we get now to the witness testifying? Because the last he stated was he was pleading the fifth. So how is he testifying? And the judge was like, he spoke to his attorney and now he's testifying. That's all I can tell you. But you had an ex parte hearing. And they didn't find that out until lunch. Let the judge say. I don't know if that was lunch, but whatever time of day that was, I remember Mr. Copeland needing to change his sweater. And I thought, well, just take the shirt off. But then I thought, oh, maybe it's the under sweater of the undergarment that he wanted to take off. Anyway, the judge may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court. If they give notice to the parties of the person consulted and the substance of the advice, and afford the parties a reasonable opportunity to respond. You know, if you're doing something extreme, if the law, I mean, not the law, if the case has something extremely technical, scientific, you might, as a judge, want to get a scientist to give you some understanding, some expert understanding, but you still have to let the parties know and give them an opportunity to respond. Hey, judge, this is proper. No, it's not proper. No, we don't, we want to voir dire this expert, we actually want them to come to trial, be on the record, whatever. Judges may consult with court staff, court officials, whose functions are to aid in carrying out adjudicative responsibilities, or with other judges, providing the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide. Judges may, with the consent of the parties, confer separately with the parties or their lawyers in an effort to so they can with the consent of the parties, judges may, with the consent of the parties, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. Okay, so that's just party specific. I don't know. I wonder if the judge could have had like a ex parte communication with ADA Hilton and ADA Love without a problem. Maybe that's probably what that's saying. But it's only to help settle the pending proceedings. And so, if you had what's the one who pled out? So that there was a defendant who pled guilty, and they were like, they're no longer a party. They pled out, and Hilton, ADA Hilton was like, no, they're still a party. The case is still going on. And then it was like, well, that's confusing because when you plead guilty and you get a plea deal, you're done. The whole thing is to be done with the case. So you're no longer a part of the case. And Hilton was like, no, they're still a part of the case. So I wonder, in the instance of that particular party, whomever that defendant was, wanting to have a ex parte hearing with the judge to settle the matter of the plea deal, if that would be proper based upon this. Judges may, with the consent of the parties, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. That probably be where that would be applicable, but I don't think it's applicable to what's actually a part of this ex parte, because Copeland is not a party. He is a witness with an immunity deal. So he's not, and I think he was ever indicted. I'm not sure. Interesting. Judges may initiate, permit, or consider ex parte communications when authorized by law to do so, such as when issuing temporary protective orders, arrest warrants, or search warrants, or when serving on therapeutic problem solving or accountability courts. Okay. Including drug courts, mental health courts, and veteran courts. Oh, okay. Diversion courts. Okay, got it. Anyway, I don't think there's any problem with that, other than he thinks the judge gives an indication that he believed it was an emergency, but he didn't give prompt notification to the parties of the ex parte communication, and they weren't, given time to respond. In fact, they had to put a motion to recuse based on the matter. And then number 5, Judge Glanville was going back and forth about safety and threats, and U.S. versus Adams 785 2nd 917, about how if safety is a concern, that the judge would in fact be meeting with a witness to help solve that particular problem and put in maybe protective orders or so forth, arrest warrants, whatever, so forth. Well, but you said the substance of the sum of the meeting was the immunity agreement. There was no what was the conversation about safety? And so how does that really play? I don't know. I guess if we ever see the transcript, we'll find out. If a judge inadvertently receives an unauthorized ex parte communication bearing upon the substance of a matter, the judge shall make provision promptly to notify the parties of the substance of the communication and provide the parties with a reasonable opportunity to respond. A lot of the thing about ex parte that wasn't really done is you have to give the other side an opportunity to respond. You have the notice, giving the other side inclination of what has transpired is what makes this so nefarious. Or one, that's the big hurdle. The other hurdle is whatever the substance of the communication was. If it's relative to what is in Weinstein's affidavit, it's a major issue, especially if there are things that relate to Brady violations. All right, judges shall not investigate facts in a pending proceeding or impending matter independently, and in making adjudicative decisions shall to consider only the evidence presented and any facts that may properly be judicially noticed. The facts a judge shall not investigate include those derived from personal observations or media, including printed publications, computer retrievable electronic data, or internet or social network communications. A judge shall make reasonable efforts, including providing appropriate supervision, to ensure that this rule is not violated by court staff, court officials, or other subjects to the judge's discretion and control, which is, of course, what we heard throughout the trial with on Massachusetts versus Karen Reed from Judge Beverly. I forgot her last name. I just learned her first name, so I forgot her last name already. But she said it all the time. Have you talked to anyone? Did you inadvertently hear anything? Or were you on the socials? So here we go. This is what it says, you know. You can't do that either, judge, or anyone else, including the jury. So judge is assuring fair hearings and averting ex parte hearings, because ex parte hearings can in fact become unfair. Because if they are unfair, that would mean there's certain advantages that is awarded to one side versus another, which is not allowed. You're not allowed to have a gain of procedural, substantive, or tactical advantage. And the judge shall perceive if it is or is not. So this judge says, no, it wasn't. And we'll find out for sure, hopefully in short order, but he doesn't get to choose who tells who what. All right, hold on one. So we got it on good authority. Judge Glanville has transferred the motion to recuse, the 3 motions to recuse will be heard by a different judge based upon their randomization, which includes putting the name on the wheel, obviously based upon their rule 25, the judicial conduct rule 20. Wait, is it judicial conduct rule 25 or just rule 25? I think it's procedural rule 25. The judge is Glanville is not allowed to have any say so in who takes on those motions and decides upon those motions. But you know what? He's the chief judge. Anybody want to rule against the chief judge? I think it would be automatically better just to send it to a different district so that impartiality can be truly expressed, because the chief judge, I would not want to decide against the chief judge who's going to decide all your cases from henceforth. I mean, you know, whatever, right? You got to do what you got to do. But nonetheless, that is going to be interesting to determine. So anyway, that's what we come to find out. And I will see you on the next video. Lyric Armstrong, your real estate agent and advocate. See you in the next video. Enjoy.